Hello everyone, welcome to FamilyLegal, an initiative by the students of NLSIU. Our mission is to raise awareness about family law, making legal knowledge accessible to those who needs it most often but don't have the resources to find it. Through our blogs, FAQs, information-driven website, and insightful interviews, we aim to simplify complex legal issues and empower individuals with the knowledge they deserve. I am Sahil Gupta, and with me I have my friend Shubham. Today we are thrilled to host our very first interview, and we couldn't have asked for a better guest to begin this journey with. Joining us is Professor Anagha Joshi, an accomplished legal professional with nearly 2 decades of experience in the field. Professor Joshi has previously served as a family court judge and has extensive expertise in areas like divorce, maintenance, child custody, domestic violence, and more. Beyond her professional experience, she has been a visiting faculty member at leading institutions like ILS Law College for over 17 years, and she is a sought after speaker at national and international forums on legal and social issues. Professor Joshi has also recently started a YouTube channel aimed at making legal knowledge more accessible to the general public. We will provide the link to her channel in the comment section. Please do check out Mem's channel. In today's discussion, we will be focusing on the topic of novel emerging grounds of divorce in Hindu law. These includes grounds like irretrievable breakdown of marriage, marital rape, and different forms of cruelty. These topics are becoming more and more important in today's society as relationships and social norms are changing. However, many of these issues don't yet have clear legal definition or recognition in the law, which creates confusion. For people seeking divorce, their lawyers, and even the judges handling these cases, this lack of clarity can make things difficult. With Professor Joshi today, we hope to dive deeper into these topics. We will explore how these issues are dealt with in courts, the challenges faced by those involved, and what can be done to make the law clearer and more helpful for everyone. We are truly grateful, ma'am, that you could join us today. With that being said, let's start with the discussion.
Thank you so much, ma'am, for taking the time today to join us on the podcast. We at Family Legal truly appreciate it. To start our discussion, I'll begin with my first question.
Yes, ma'am. I wanted to ask about the irretrievable breakdown of marriage. So we've discussed it a lot in law school as well. However, none of us are very certain about the topic because of its confusing nature. It has not been codified in any of the statutes either, and the Supreme Court from time to time has used its extraordinary powers to interpret a few cases under the light of this new ground. So, since Professor, you've held the unique experience of engaging with these issues in different capacities, that of a judge, where you've interpreted the law, then as a litigator, where you've advocated for clients, and even as a educator, where you've guided students like us through these difficult topics. So, in your experience, would you say that this ground of irretrievable breakdown just a topic for the textbooks for law students to study, or is it actually used in courts by practicing litigators and parties alike?
Okay, so see, when do we talk about the grounds of divorce? As of now, our Hindu Marriage Act, Special Marriage Act for that matter, both these enactments, if you go through the grounds of divorce, then you will find that these grounds are based on two theories of divorce. There are theories of divorce. Out of that, two theories we are using. The first theory is fault theory, wherein the petitioner is going to the court saying that respondent is at a fault. Like if husband has filed a petition, then wife is at a fault. Wife has filed, then is at a fault. So the petitioner is seeking divorce for some or the other wrong on the part of the respondent. Okay, that is
Yes.
one theory which has been used. Another theory is consent theory, wherein both the parties they do agree for the divorce, they consent for the divorce, and therefore the court will grant them the divorce.
Yes.
Now, going beyond these two theories, when are we talking about these two theories, we first need to take into consideration that India is a nation, the family culture which has been enriched not only in India but worldwide. We know that our family culture, our joint family system, and everything that has been admired everywhere. Now, many a times now I get to hear like from my friends, from people like you youngsters, if at all a couple has completed matrimonial life of let us say 50 years, 60 years, then someone will pass a comment, 60 years together, how is it possible? Okay, so what had happened is the society is changing. Okay, so initially only fault theory was there, and later the mutual consent thing was introduced. When we talk of the Hindu Marriage Act, basically the Hindu law, the religion as such, or Hindu law, it never ever recognized the concept of divorce because it's unity of souls, and therefore this unity cannot be disrupted. And the concept of divorce was very new for the Hindu people when it was introduced in the year 1955. So, when you talk about whether irretrievable breakdown of marriage is only a part of curriculum, and is it that we just read it and leave it after our curriculum, it is not like that. Yes, no doubt. As of now, it is not ground for divorce. No doubt about it. And there is a debate whether it should be made a ground for divorce or not. And therefore, I won't say that it is useless topic which is only there in your curriculum. Rather, I would say that you should get all the knowledge as far as this particular theory is concerned, irretrievable breakdown of marriage, basically for two things. The one is in the year 2010, rather, the bill has been passed in the Rajya Sabha. It is not yet enacted. However, it has been proposed that irretrievable breakdown of marriage should be considered as a ground for divorce. One thing. Another thing is Law Commission has time and again said that irretrievable breakdown of marriage should be considered as a ground for divorce. And yes, Supreme Court in many cases has considered this, has used its inherent powers and has granted divorce as far as irretrievable breakdown of marriage is concerned. So I would say that irretrievable breakdown of marriage is only for the theoretical purpose, and in real life it cannot be used. In real life, yes, it can be used. We as a lawyers use it. The only thing is, why are we not using it, or why the legislature is not legislature, the courts are not using it? Because it's not there in the law. The courts, we lawyers are not allowed to use something which is not there in the law. So if you go to the Supreme Court, yes, no doubt, Supreme Court has all the powers, but trial court, as you said, this is the reason why trial court, they don't recognize this.
Okay, that was pretty clear, ma'am. Thank you. That really clears up a lot of confusion we've had on the topic since we've studied it. Ma'am, you mentioned that usually trial courts are not to keen to accept arguments based on breakdown because it is not there in the statute. Professor, do you think, like, since the Law Commission has recommended its inclusion, and even there has been a bill passed which includes that as a requirement, and you've also talked about societal views on marriage have been shifting from to focus more on individual autonomy and dignity rather than the view of a Hindu family as a sacrament. Professor, do you think that this time, right now, is right to formally recognize, be it grounds such as irretrievable breakdown of marriage, or even other grounds we'll discuss in the future, such as marital rape or cruelty, various grounds within cruelty. So, do you think this time is right for India to formally recognize these grounds? And do you also think that since these grounds are often no fault divorce options, where fault from either party is not required, such as in breakdown, do you think that when the law comes for irretrievable breakdown, any safeguards or protections should be read into the law as well to protect, say, spouses who are not very financially well off but could suffer from grounds such as these, perhaps stronger maintenance provisions or other likewise?
See, when we talk of irretrievable breakdown as a ground for divorce, basically the bill is not yet passed, the bill has been introduced, so it is not yet law. Whether to accept it or not, whether to have that ground or not, again, if you go through the very recent judgment of Honorable Supreme Court, which talks about the irretrievable breakdown of marriage, is Prabhamani versus Lakshmi Misha. Now, as far as this particular case is concerned, you can go through the facts of the case. The husband had initiated the divorce proceedings. Initially, it was on the fault ground. The lower court, the trial court, granted the divorce. Matter reached up to the Supreme Court. The divorce was dismissed. Again, husband filed for the divorce. Rather, it was referred back to the trial court. and again the divorce was passed on the ground of irretrievable breakdown of marriage. Now, as far as this particular case is concerned, what Supreme Court has observed, that irretrievable breakdown of marriage. What is irretrievable breakdown of marriage? That parties have not stayed together for a continuous period. Now, if you go through the provisions which are there in the bill, then they use they use the period of 3 years. Okay. Now, when are we talking about today's scenario? What the Supreme Court says, that if the parties are staying separate for quite a long period, and if it is the case that now they cannot stay together, like see, the parties, they are separated, let us say, for 10 years. We do see such kind of parties in our day-to-day life, because our litigations, they do remain pending in the court for years together. So let us say that husband and wife, they are litigating before the court. They have made allegations and counter allegations against each other. They have been staying separate for 10 years. So is it practically possible that they will come together? The answer is no. And therefore, at some point of time, yes, we do feel that irretrievable breakdown should be the ground for divorce. But at the same time, we need to consider that the Supreme Court has said this. And therefore, as I said, that our law is basically based on the fault theory. So if you go through the judgment of the Supreme Court is again shifting from irretrievable breakdown to the fault theory. Now, what had happened? The Supreme Court said that as far as this particular case is concerned, the case which I referred, it was the husband. Because of the husband, the parties didn't stay together. Because of the husband, there was round of litigations against each other. There were allegations, counter allegations. So whether the party who is at a fault, because the laws, the matrimonial laws, they also have the provision that if the party is trying to take advantage of his or her own wrong, then in that case, even if the party proves his or her case, the relief will not be granted. Now, if that is going to be the case, then if that particular principle is applied to the ground of irretrievable breakdown of marriage, then again we are going to the fault theory. We are purely not considering irretrievable breakdown of marriage. Now, the bill which is introduced, the bill also, as you said, that if the wife is going to be rendered the penniless, or if there is a child, then what about their maintenance and all that stuff. So, as you said, there is a view that some punitive measures, like the person who is going to the for that matter husband, because over there the word wife is not used. So for that matter, if husband is the initiator who is saying that it's irretrievable breakdown of marriage, then he should pay certain hefty amount to wife and all that. But will that be really the good thing? Whether husband will really be in a position to pay that amount is also a question. Another question is, why only the husband? Again, now if we are talking about the discrimination, because the bill itself, it says that it is aimed to curb the discrimination, gender-based discrimination. Rather, it wants to eliminate gender bias. Now, if we want to eliminate gender bias, then again putting this only on the husband is going to be the gender bias. So, who is responsible? Irretrievable breakdown of marriage, then in that case, if that ground has to be considered as a ground for divorce, then in that case, it has to be studied and it has to be worded in a very clear language, that because see, now again there will be a question. Okay, that particular person is at a fault. He never ever wanted to have that marriage, and therefore he separated from the wife, or she separated from the husband. Then, if see, again there are two aspects of it. Because that person is responsible for the irretrievable breakdown, is it that you are not going to allow him the divorce? Then isn't it again violation of his personal rights? Isn't it violation of his liberty? So again, these two aspects we need to consider, and therefore, if you go through the judgment which I referred of the Supreme Court has said all these things, but ultimately Supreme Court has granted divorce by putting certain conditions, that husband should make so and so provision for the maintenance and all that. So yes, Naveen Kohli, Neelu Kohli is the case, old case, in which the Supreme Court has really discussed about the irretrievable breakdown of marriage. And yes, I do feel that if parties are litigating against each other, let us say for years together, they are not going to come together. The element of vengeance, element of revenge is many times is there when they litigate for years together. So if the party is litigating merely out of that feeling, then in that case, somewhere that has to be stopped. Somewhere the trial courts should be allowed to stop it. But as I said, we need to consider a number of things. Though the society is changing, it is not possible to, what we say, it is not possible to disrupt society as it is. Like, okay, now anybody can go to the court and say that my marriage is irretrievably broken down and give the divorce. Then it will be like the playing with the system, playing with our marriage institution rather. So, yes, if it has to be introduced, then it should be introduced in a well drafted manner, wherein it should be considered purely as irretrievable breakdown. It should not be again confused with the fault thing. Okay.
Yes, ma'am, understood. Thank you for that explanation. That really helps us with a lot of things. Even when we studied the topic of irretrievable breakdown at a law school, we couldn't really appreciate the different dynamics it has, such as that of gender. And even if we say that society is changing, your insights on how even the society is changing, you cannot just put irretrievable breakdown on society and expect that no consequences would arise. Those insights were really helpful. I also think that more literature and perhaps even legislative discussion is probably needed on this topic from both lawyers, professors, and even legislators. Professor, a similar topic to this, which is also currently undergoing a lot of discussions, has been one of marital rape. Sahil, if you want to continue the questioning on that front.
Yeah, so the second round we want to discuss with you, Professor, is of marital law. It is very sensitive topic and very contentious issue in India. Just to set up the context, Supreme Court is currently a case in Supreme Court is going on this. It is a topic that strikes at the intersection of personal autonomy, societal norms, and law selectance interference in the sanctity of marriage. Although this is not explicitly recognized as a ground of divorce, but court are giving some very occasionally divorce on this ground, like very occasionally, and this shows a clear lack in the legal recognition that this topic needs to get. So on this topic, I like you to give some insights. Like, is are we really talking sufficiently on this topic? Do you think the lawyers and litigants are sufficiently aware of this argument, and it is still underutilized or overutilized due to the stigma that surrounds this issue?
Okay, see, when it comes to the marital rape, basically, when do we talk about the sexual intercourse, or rather, when do we talk about the physical relationship? Let me be very frank, leave aside the marital rape. The people, many a times, they are not aware of the fact that if at all there is sexual assault, then in that case, it can be remedied by the court. That can become a ground to go to the court. One thing. Another thing is completely opposite to this, impotency. Like we are talking about the rape, but completely opposite to this, impotency. The people, they don't have insight about that they can challenge this impotency or they can get relief against this impotency from the court. So yes, basically this particular topic is not at all being considered, or rather the lawyers as well as litigants, they are not aware of this particular topic. The question is, or rather the cause of this, the reason of this might be because we don't have marital rape as a ground for divorce, one thing. So there is no discussion on that. Nobody will thought of it. See, what happens is, we do, when are we working, we do go by the texts, we do go by the law. So we try to find out where my case fits in which particular section. So usually the lawyers, they also don't talk of the marital rape because it is not a ground. One thing, no awareness is there. Another thing, and when it comes to a woman, a lady, a woman is not willing. It always happens that whenever such a topics are there, she is not willing to discuss. She is not willing to talk about it, not only about the marital rape, even the other kinds of rape, or for that matter, sexual harassment. Okay, now when we talk about the marital rape, Kerala High Court recently has considered marital rape as a ground for divorce. And yes, as you people said, in Supreme Court also the discussion is going on. There are arguments as far as this particular topic is concerned. One group is saying that it should be considered as a ground, and another group is saying that no, it should not be considered as a ground for divorce. So yes, as of now, there is a dilemma. I won't say there is a dilemma. As of now, it's not a ground because there is no question of dilemma. And yes, there is no awareness that this marital rape, it can be used rather. Even if there is no provision, yes, that particular can be used in some other way. But that awareness is also not there, barring very few lawyers.
So, Professor, as you said, so marital rape is not formally recognized, but it is to be recognized as a separate ground for divorce. It would be undoubtedly a landmark change. But what will be the practical challenges, especially around the evidence and procedural safeguards of this? Like, what would you think the will be the hurdles if marital rape it will be recognized as a separate ground for divorce? And there is also an argument of potential misuse, as you said that there is parties from both sides that are constantly arguing on it. So there is argument that there are so much potential for misuse of this ground. So what would you think that there? What would you propose to ensure that there should be fairness while still protecting a genuine victim?
See, when it comes to the misuse of a law, potential misuse of a law, we can't say that law should not be there with the fear of misuse. Law is like a knife, isn't it? You use it properly, you use it, let us say, for the surgery, for saving a life, or you use your knife for killing another person. Knife is not bad, isn't it? Knife has to be there. The main issue is uh, whether, because the law will be misused, we are not going to have the law. Wherever it is necessary, wherever there is a need, because we are in the society wherein if you are saying that I have certain right, then in that case there has to be a remedy to protect that right. So this cannot be an argument that it will be misused and therefore there should not be law. The question is whether there should be law or not on some other aspects. Why? Because when we talk, see, um, when we talk of a rape under IPC, the concept of rape under IPC, it's essentially a kind of penetrative sexual intercourse, right? Now, when we talk about the penetrative intercourse, uh, and we compare it with that of the marital relationship, see, Hindu law says that it's a union of soul and the sanctity and all that stuff. Let us put it aside. Let us be very practical. Let us be very straight as far as concept of marriage as of now is concerned. The marriage is nothing but legalizing the sexual intercourse. Let us put it in very clear language. Okay, now if you uh, this is the institute which we are considering as something which legalizes the sexual intercourse, meaning thereby a man is marrying a woman for the sexual intercourse so that he should get that pleasure. So also a woman, a lady is marrying a man to get that particular pleasure. Okay, now the question is if one spouse, because when are we talking about the marital rape, again we are making it biased. Again we are discriminating it. A man versus a woman, isn't it? Because penetrative intercourse, what are we talking about? The term penetrative intercourse. So if at all the very objective, very ground behind the marriage is getting that particular pleasure, and let us say one partner, now since we are talking from the perspective of a woman, from the perspective of a lady, I would say if at all a lady is saying no and husband wants that particular pleasure, then in that case whether a lady can say that her husband is guilty of rape. If she was not ready, then in that case she should not have entered into this particular relationship. Because when we talk about the rape cases under IPC also, we do find out, the courts, they do try to find out whether that particular relationship was uh, consensuous relationship or not, whether whatever had happened happened against the wish of a lady or not. So if a lady enters into the matrimonial tie, meaning thereby she was also willing to have this particular relationship, one aspect of it. Another aspect of it is, we are saying that there is no ground of a marital rape. I won't say that it's not a ground. It is not a ground, separate ground. But see, when we talk of a cruelty, nowhere cruelty has been defined in Hindu Marriage Act as well as in Special Marriage Act. Initially, the Hindu Marriage Act had put certain restrictions when we talk of a cruelty, but now it is not there. So, what is marital rape? If at all a lady is saying that her husband is sexually pervert, for that matter, if at all a lady is saying that her husband sexually assaults her, if at all a lady is saying that her husband wants her to have unnatural intercourse, or some or the other kind of allegation, then no doubt a lady can go under the ground of cruelty even as on date. We do that in the petitions. As I said, yes, marital rape as such is not a separate ground. But yes, we do have that particular ground of cruelty because this is cruelty. You can put it as exceptional cruelty. There is no wording used exceptional cruelty. I know that. But yes, you can put it in that way, and then courts are there to see whether your case stands or not. One thing. Another thing is, whenever we do talk of a rape, in IPC also, when we are handling the cases of rape, it's a heinous crime, isn't it? It's very serious allegation, and therefore usually uh, uh, the proof we do call, like, what should be the proof for that standard of proof. When we do talk about it, what kind of proof a lady is going to get if at all she is talking about the marital rape? Okay, and remember, the Supreme Court in n number of cases in has said that if you make a false allegations against your wife in a petition, then the false allegations in itself will become cruelty to the other spouse. Now, see, we are making we are putting a ground of making the allegation of marital rape. From where are you going to get the evidence for it? And rape is not something you, it is not merely a cruelty. Rape is something which is very grave, and if wife is not able to prove that, then husband might use that against her, saying that she is making false and baseless wild allegations against me. So I do feel that whenever we are talking about the matrimonial rape as a ground for divorce, I do feel that law is there already to take care of this. We should be able to use the law. If we are not able to use the law, then it's of no use in blaming the legislature.
Yes, ma'am. Thank you
Yes.
so much for your insights on marital rape, your insights on the element of consent there, your insights on how it can be used under cruelty as a ground for cruelty. And what I particularly found interesting was how you said that the burden and proof on the wife to prove offenses like this is very high, even for the cases that we studied in our course curriculum, or even recent judgments which have been catching a lot of traction in news, such as the recent Aurangabad High Court judgment of cruelty, where the woman killed herself due to cruelty. However, the judge said that since there was no proof of because there was no concrete proof of cruelty being there, all the accused were acquitted. Various cases like this also point to the fact how difficult it is for the wife to prove offenses, be it domestic violence, harassment, cruelty, especially when it's something like mental cruelty, to prove these offenses before our traditional courts of law. Professor, I wanted to continue from our discussions on cruelty. From what we studied ourselves, cruelty does not have a definition anywhere, be it in the Hindu Marriage Act or any other statute. Um, our professor explained to us that this ambiguity was there to allow courts to adapt this concept over time, incorporate elements such as mental cruelty, emotional cruelty, um, denial of intimacy, or even marital rape. While this flexibility reflects evolving social norms, at the same time, multiple lawyers have pointed out how this poses challenges in ensuring consistency and predictability in court judgments. From your perspective, the undefined nature of cruelty, do you think has it been more of a boon or more of a bane? Has it allowed us to get a more nuanced understanding of these marital disputes and lead to more just outcomes, or has it led to inconsistencies that make it difficult for both parties to predict outcomes?
Yes, cruelty is not defined. Domestic Violence Act is the enactment which does talk about what is domestic violence. Okay, they have given the definition of domestic violence, and it runs in a 1.5 page, I guess. But at the end of it, again, it says it does not say that this is the violence. I mean, this is the only violence. Because see, when we talk of a cruelty, cruelty can be mental cruelty, emotional cruelty, what we call it, and the physical cruelty also. Now, why it has not been defined? The reason behind it is, see, we are trying the cases, or we are talking about the cases wherein the parties involved are from various strata of the society, their social background, their educational background, other aspects, they are of such a varied nature that we can't define cruelty, because cruelty will change not only as per time. It's not merely because, see, law has to be dynamic to change as per the changing needs of the society, no doubt about it. But it's cruelty is such a thing, it is not merely related to a time, that the concept is going to change from a time to time, but it changes from person to person. It changes from society to society. It changes from even the place to place. Okay, so why the this particular word is not defined? So that there should be, so that the court, so that the lawyers, so that the litigants can come before the court, can go before the court with any kind of act, if at all he or she is feeling that it is cruelty. Okay, now there is the court, the judge will decide whether it is cruelty or not. So, what do we feel? That it is up to the judge to decide whether it is cruelty or not. Then this is something which is not concrete. Then this is something wherein we are ending up in a chaos. It is not the situation. Please try to understand. The Hindu Marriage Act, let it be Hindu Marriage Act, let it be Special Marriage Act. The objective behind any of the divorce law is not to give divorce. Okay. They have made provisions for divorce. Why? Because it was a need of time. No, we can't say like, no marriage cannot be broken down and all that stuff. We have moved ahead. So the objective is not to break the marriages. The objective is to save the marriages. One thing. Another thing is, when we say that courts are to decide whether a particular act, incident is a cruelty or not, it does not mean that everything is dependent on the judge and it is going to create a chaos. See, the Supreme Court in n number of cases has very particularly said that the cruelty should be of such a nature that a person should not be expected to live with another person. Now, when are we talking about such a kind of cruelty? Uh, then, in that case, I will give you an example.
Yes, ma'am.
Cruelty is something which is subjective, which is relative. I always give this example because this is very simple example. A lady who comes from lower middle class, okay, if she is required to do the household chores, then one part of it. Another part of the example is a lady who is at a very high post. She herself is getting a very good salary, handsome salary. Her husband is also at a very high post. He is also getting handsome salary, but she is compelled to do the household chores. Now, see, with the social background, with the background, economical background into cases, the concept of cruelty will change. For this first lady, doing household chores, we can't say rather that this is cruelty. Everywhere, everybody, it's not about only wife, even the husband, everybody from the family, they have to take part in the household chores. Okay, but when it comes to the second part of the examination, a lady, if at all she is required to go out, if at all she is required to handle her job tensions and everything, and if she can afford the help, then why not? Then compelling her to do the household chore and do her job and do and manage everything is going to become cruelty for her. No doubt about it. Okay, so cruelty is something which is relative. So what, when are you pleading your case before the court, you have to plead it in such a way, or rather, you have to take care of putting all these aspects before the court. So court will not say that no, this is not a cruelty. What the Supreme Court has said, normal wear and tear of matrimonial life is not a cruelty. What does that mean? Supreme Court says that tell me any matrimony wherein there are no disputes. And the husband is filing a case saying that my wife fights with me every day. I have seen such a kind of pleadings. This cannot be everyday fights. Then misunderstandings. In which relationship there are no misunderstandings? We do have misunderstandings with our parents, we do have misunderstandings with our friends, with our fellow colleagues, with our siblings. Is it that everywhere we are going to say that no, now I'm not going to be in this relationship because there are misunderstandings? So cruelty should be, see, again we let us come to the same the first part itself, with which we started this question answer session. We stay in India. Okay, the family system, this particular system is our core, this is our core value. Why this is our core value, please try to understand. It is not something which is like orthodox thinking or something like that. Whenever there are children in a family, the children, they need the family, they need both the parents, they need such a family wherein their parents, they are happily living, wherein they are getting love and affection of both the parents, caring, etc., etc. If at all children are there in a disturbed family, then in that case we have seen that the children, they do develop with certain one or the other kind of mental traits. That should not happen. We need to protect our children also, we need to protect our future generation. So it is not something orthodox view, it is something you have entered into a relationship. Be loyal to to your relationship, don't be immature, be mature. Going asking for the divorce on some paltry grounds, some uh, flimsy grounds, that should not be allowed. And therefore I don't feel that this concept of cruelty is vague, and we do end up in the chaos. How do we put our case before the court? What kind of cruelty? Why are we saying that I can't stay with this person? Be elaborative, be specific, uh, uh, convince the judge that this is cruelty to you. And then I don't think that there is going to be any challenge as far as the case is concerned.
Yes, yes, ma'am. Thank you for that. It actually makes a lot of sense now that we revisit the cases we've had in our course. It makes a lot of sense why the pleadings were so specific and why the fact situations were so long. Family law is very context specific, and like you said, cruelty even more so. It very much comes down to what the context is, such as is the wife earning or what, or even the presence of children. Professor, from lawyer's point of view, our main goal would be just to put as many favorable facts as we can to the judge. Professor, you've been a former judge as well. So, as a judge, how do you think courts usually strike this balance between adapting to societal changes and maintaining judicial restraint? How exactly do courts, when they are faced with cases like this, especially of cruelty, how do they exactly draw the line to avoid overstepping and still ensure that the outcome which they ultimately give to the family is just?
Uh, you are talking about the judge's own perceptions and everything, right?
Yes,
See, if you have studied jurisprudence, then in that case you must have studied who makes the law. So we have n number of theories, and out of that, one theory is legal realism. That it is judge who makes the law, because whatever is there in the law, ultimately judge's own perceptions, background, upbringing, etc., etc., uh, uh, will come into the picture when we talk about the um, giving a judgment. And ultimately the judgment is important. Whatever has been mentioned in law is not important. What the verdict judge has given is important. So I do feel that as a judge, every judge tries to be impartial. Okay, impartial. I'm using this particular word not for the parties, litigants, or for the lawyers. Impartial meaning thereby impartial from the point of view of their own perceptions, their own way of thinking. Okay, like I being a particular human being, I might have certain mindset. My patience might be very high, or I might be short tempered, whatever it is. Now, whenever the cases are coming before me, whenever the cases are being tried before a family court judge, always remember, even judge is a human being. Even judge has his and her or her own family. Even they might have gone in through the similar kind of situations or something. So if judge tries starts to relate everything with his or her own personal experience, and if tries to put his or her own perceptions in her judgment, then in that case that cannot be considered as a justice. Okay, so usually judges, they don't go by their own perceptions. um, though we are rather the family court judges, though they are handling human emotions which are of varied types, the Supreme Court has in n number of cases has discussed n number of aspects as far as matrimonial litigations are concerned. Dastane versus Dastane, which is a case of 1975, but even as of now we use that particular case. Samar Ghosh, Jaya Ghosh. So these are some landmark cases wherein the Supreme Court has given certain guidelines to the judges also, as how the judge should consider each and every case. Okay, so I do feel that there is a very little scope, or usually the judges, they don't go by their own perceptions. They do go by whatever has been put before them by the litigants and by the lawyers. And therefore, I said this is something beyond the topic, but I would like to say that what is important is how you put your case before the judge, how you plead your case before the judge. If you are not putting your case before the judge properly, if you are not pleading it properly, and then blaming a judge, it might happen that you have got a very strong case. Okay, it might happen that judge is also seeing judge also can see that you are a sufferer. Okay, but if in black and white, whatever material is there in front of the court can't use their own feeling, gut feeling or sixth sense, something like that. So whatever is there on record in black and white, evidence, pleading, court is going to use that. So one has to be very careful while going before the family court, because this is not the civil law wherein everything will be defined on the basis of documents. This is something wherein, like we are talking about the cruelty. So see, let us say in the year 1960, for that matter, after the Hindu Marriage Act was enacted, if at all a wife would have said that I want to take further education, or I want to do a job, I want to take up a job, and I will be staying, let us say, somewhere else from my husband, then husband might have said it's cruelty to me, I'm saying her not to take up this job. So the judges might have gone with him that yes, this is cruelty. But if we consider uh, uh, today's scenario, and if the husband goes to the court saying that I'm telling my wife not to take up a job, she is not listening, this will not be considered as cruelty by any judge. Let it be any judge, even if he is orthodox in his mindset, he will not do that. Okay, so it's not that uh, the judge's own perception plays a vital role. Yes, it plays a role, no doubt about it, but not beyond particular point.
Yes, ma'am, that actually makes a lot of sense. When we studied realism, we oftentimes ended up just blaming the judges that, okay, they create the law, they have a lot of discretion to do anything or even change law as a whole.
Always
But
remember,
yeah,
always remember, law is supreme.
yes, ma'am.
Judge is not above the law. Okay? Judge is there. Judge, we can say that judge is one part of the legal system. He is not above the law. Judge is not supreme, law is supreme.
Yes, ma'am, judge is not supreme and law is supreme. And now that you explain it to us so well, even our jurisprudence classes make a lot of sense. How oftentimes it is not exactly the judge in whom we need to find the fault. Oftentimes, it is how well the lawyer is putting the case across because the judge will be impartial. But he will be impartial only to the facts which are given to him. If the facts themselves are impartial, then of course we cannot expect a judge to just we cannot expect the judge to know what has not been said. Really thank you so much for those insights. All of our family law cases and jurisprudence courses are really making sense to us now. Professor, we've taken a lot of your time, but I was just curious, so I just have one final question to ask you. Like, since we've discussed irretrievable breakdown, marital rape, and even cruelty, many of these are emerging grounds which are like within cruelty itself, there are many more grounds, and these grounds are emerging. They have not yet been codified in a statute or anywhere, but many people, even academicians or lawyers, say that they will soon become very important grounds for divorce. So, apart from these, in your experience in the courtroom or even in academia, do you see some other grounds apart from these, which say in the next couple of years could become very important for us to know about, especially
Uh,
in light of especially in light of say increasing, be it societal change or be it introduction of technology or otherwise.
See, new technology, the changes in society have given rise to divorce cases, no doubt about it. Um, Changing scenario, changing norms of the society. We could see, I mean, uh, the the number of filing. I mean, when we talk about when I started my practice way back in the year 2005, for that matter. So at that particular point of time, the number of cases that used to be filed in the Pune family court, and now the number of cases that are filed in the Pune family court. At that time, there were 5 courts. Now we do have 9 courts. Still, we feel that we need more courts. So this is the exponential growth in the matrimonial cases. However, to be very frank with you, I had never thought of any ground, a new ground, like we discussed about the rape or irretrievable breakdown of marriage, for that matter. Because I do feel, when I interpret a matrimonial law, I do feel that something which is not there mentioned categorically, we can put that under the ground of cruelty, because cruelty has nowhere been defined, isn't it? So whatever is there can be put in the category of cruelty, is what I do feel. And therefore, truly speaking with you, I never thought of a separate ground to be introduced as far as this particular uh, laws are concerned, because everything can be put under the cruelty. Even the irretrievable breakdown of marriage is completely different part of it, but also yes, that also can be somewhere we can club it with the cruelty. Marital rape, that can very well be put in the cruelty. What I do feel as of now is, um, adultery is one of the ground of divorce as of now. And we know adultery, what is adultery, having extramarital relationship. In short, I would say that nowadays we do come across with the cases wherein there is no actual adultery. I mean, it happens that the persons, they have not met in reality. Whatever is happening virtually. Okay, so when we talk of an adultery, essentially there has to be an act of adultery to make it a ground for divorce. Now, over here, when are we talking about, like, a person will come to me and say that, look, My wife is always chatting with some other person, either on Facebook, Instagram, WhatsApp, for hours together at late night or something like that. Now we can't put that particular aspect in the adultery, isn't it? But yes, my wife, my husband is more involved in someone else, and he or she is not giving the time, is really something which is annoying. So, as I said, I can put it under the cruelty, but I feel that this should be considered as one or the other ground. There should be some legislature thought on this, and that will happen. That will come, no doubt about it.
Yes, ma'am. Understood. Thank you so much for those insights. Especially when you said that cruelty is just so broad that you could put any emerging or any other ground under it. That makes a lot of sense as to even the earlier discussion which we were having as to why cruelty was left undefined and ambiguous in the first place. And even with respect to information technology, while it has been increasing, I also agree with you that there needs to be more legislative thought on this, and even like more legislative thought on this to look at any further grounds, or do we just end up putting that under cruelty as well? Thank you so much for giving us your time for this interview, ma'am. The insights you shared today with us for all the three, all the three or four separate grounds of divorces we discussed were really helpful. Your understanding of these emerging grounds not only clarified many of our own doubts regarding a course, but also inspired us to think more critically about the intersection of law and society. I'm very sure that even to everyone watching this video, be it law students, lawyers, or even parties who are in need of advice would find this really, really helpful. I think like discussions like the one we've had today are vital, not just for lawyers, but everyone who is navigating the scope or navigating family law, which is such a chaotic topic like we talked about in general. Uh, we are immensely grateful for your time and expertise. You've given us an hour, like it really means a lot to us and our initiative. And we hope to have many such enlightening discussions in the future. Thank you so much, ma'am.
Thank you. Always welcome.
Thank you, ma'am.